Application in Human Genome Sciences Incorporated and Eli Lilly and Company Limited.
Mr. Thorley.
My lords, my ladies, as you can see, there's been a slight change of personnel since the Court of Appeal. I have been re-instructed on behalf of the appellants, HGS, and appear with Mr. Tappin. Mr. Waugh appears for Lilly without Mr. Burse, who has now taken the line of least resistance and accepted a judicial appointment. My lords, my lady, this is a hearing as a result of the Registrar's letter of the 7th of July, which raised 3 questions. As you have probably seen from the inter-solicitor correspondence, the parties have put their heads together and, subject of course to your lordship's approval, they're agreed on the 2nd and 3rd questions.
Yes, well, you are to be congratulated on having left us so relatively little to decide. Since both sides are agreed about which issues we should hear, we have had a word about that, and we agree that we're certainly not going to go against the combined view of the bar as to what we should do on that.
I was going to inquire whether we could pass on to that which is in dispute.
Yes.
So far as timing is concerned, there's nothing very much between us. My learned friend thinks 2.5 days and 1.5 days, if more, if the other issues come in. We think 3 and 1 plus. Yes. So there's basically nothing between us on that. The fact that we are agreed that in one eventuality there may need to be a further hearing in the Court of Appeal on the image clone issue is of course material to the question as to whether the other issues should come before your lordships or go back to the Court of Appeal, because there is going to be on that eventuality the possibility of a further hearing in the Court of Appeal. I can well understand that if the parties had agreed that there was a possibility of the Supreme Court dealing with all the issues, that might be an attractive course. But one does have to bear in mind that there may be a hearing on this image clone issue, which I'm not going to weary you with further today. Can I turn then to the issue which is in dispute, or the issues which are in dispute? Put compendiously, we call them the antibody issues. Not entirely correct, but an easy way to identify them. They are distinct from the industrial application issues, and indeed distinct from the image clone issues. They raise different questions of law, and certainly raise different questions of fact. My learned friends have suggested in their skeleton that
Could I just ask you one little detail, that they're identified in both sides' skeletons as arising on claims 13, 18 and 19.
Correct.
Looking back to the appendix to Mr. Justice Kitchen's judgment, one then finds one set of numbers and another set of amendments, but neither set corresponds exactly to 13, 18 and 19. Where do they come in?
This all came out of the EPO appeal.
I see.
When amendments were dealt with and allowed, and certain claims were disallowed as a result of the renumbering. I'm going to get this probably wrong, but what were 20 and 21 became 18 and 19.
Yes, I think that's right.
And so now, whenever one looks at Mr. Justice Kitchen's judgment, one's mentally got to transpose the numbers, but the issues remain the same.
Yes, thank you.
And they are in effect, claims 18 and 19 relate to antibodies for diagnostic use, whereas claim 13 is more general. And it's one of those aspects of patent law where the more general claim was held to be valid, whereas the specific claim was not. But nothing turns on that for present purposes. They all go hand in hand. And my learned friend's case appears to be that they are more nearly related to the industrial applicability issues, and that in some aspects of the antibody issue will be raised by them on the industrial applicability issues. Or he refers, I'm not going to go to his skeleton, you will have read it, but in paragraph 27 he talks about the putative function of antibodies. and indeed refers to Mr. Justice Kitchen's judgment in paragraphs 34 to 50, where he sets out the background to antibodies in very general terms. And frankly, for the purposes of industrial applicability, we would suggest that probably that is all that the Supreme Court will need to be educated upon for the purposes of that issue. Whereas when one gets into the question of sufficiency and the diagnostic materials claims, we will have to get into more detail. And one can see that, and I don't need to go into details today, but one can see that for the fact that the parties are agreed that if this court does take on the antibody issues, the length of the hearing is going to be increased by about 50%. And that, we say, is a perfectly sensible recognition by both parties that if one is going to go into the antibody issues, the House, I'm sorry, I'll learn eventually to address you correctly, I apologise. The Supreme Court will have to be educated rather more deeply on antibodies than would be necessary for dealing with the industrial applicability aspect. And one can see that from the structure of Mr. Justice Kitchen's judgment when he deals with this as a separate issue between paragraphs 246 to 260. And again, I wasn't going to weary you with it unless you wish to look at it. It is dealing with separate aspects of technology, and indeed the parties, because we lost on one issue and my learned friend lost on one issue of this aspect of the case, were given permission to appeal on those issues as a separate issue. So, my lords, my lady, there's no getting away from the fact that this is a significant issue in its own right. What we would also draw to your attention is that the nature of the appeal in relation to those issues, which is set out, if your lordships, my lady, have our skeleton argument. It's really raised in paragraph 10 when we indicate what the nature of our appeal is on issue A3. And if you'd be kind enough to go down about 12 lines, you see there's a reference to Mr. Justice Kitchen saying he found in favour of Lilly on this point, referring to evidence relating to the ease of identifying and neutralising antibody as a candidate for therapeutic or diagnostic application. HDS appealed on the ground that he'd overlooked critical evidence from the experts and had wrongly addressed the ease of identifying a use, indeed all the uses, for such antibodies rather than producing them. So this is going to be the sort of appeal in the Court of Appeal when one would be saying to them, look, there is an error of principle here. The judge has failed to take into account evidence which he should have taken into account, and will obviously there involve not an overburdensome trawl, but a trawl through the evidence, which is, I apprehend, not a matter that, in the normal course of events, the Supreme Court would be over keen to involve themselves in. So
there's no point of law at all, really, is there, in this?
One can never say there's no point of law in the sense that until the Court of Appeal have given their judgment, one cannot turn around and say, I always say to my clients, let's discuss points of law once we've got a judgment. I think your lordship may be absolutely right that on this aspect there may be no point of law, but I'm afraid I'm not going to say here and now today that I'm sure there isn't. Fundamentally, your lordship is absolutely right.
It's just a matter of case management.
It's a matter
as a result of the fact that the Court of Appeal
didn't deal with it. And that is where I draw your lordship's attention to the fact that image clone is going to have to go back anyway. So one's not going to obviate a further hearing. And it's really, if I may put it this way, out of sympathy for your lordships and my lady, that we suggest that you're going to have to get a load of technology on board, and perhaps you may feel that enough is enough with the issues you'll have to deal with. I should just say in parenthesis, since the skeletons came in, Dr. Murphy has indicated that he would be available to assist the court if that was suitable. His new employers have agreed that he may have the time off.
He's just moved to the University of Westminster.
That's correct. He's just moved, and literally it was last week that he started. And he had to go and see his lords and masters to say, please can I have time off?
Well,
They said, yes, he can.
We have again had a word about that. I think that the court will welcome Dr. Murphy's assistance, though the precise form that it takes obviously will have to wait until we're nearer the hearing and we know what constitution will be sitting.
Yes, well, again, anything that we can do on this side to assist in that, of course we shall do. And if there are any briefing papers or things that the court would like, they can be provided. And happily, this is a case where there isn't a great deal of animosity between the parties, and therefore we are able to speak to each other in a constructive way, which occasionally doesn't happen, but happily in this case it does. So anything we can do to help, we shall do. So I come back to really the substance of the matter is that is it right, is it proper that this court should take on board issues which have not been subject to the coarse sieve of the Court of Appeal, which may or may not involve a point of law of general public importance. We certainly can't at the moment suggest that these issues do raise a point of law of general public importance. And we suggest that in those circumstances this court might well benefit from having a judgment from the Court of Appeal on which they could decide whether this court should have a further hearing, and it will absolve you of picking up more technology than was absolutely necessary. Subject to that, on the other side, of course, if you were to take it, it would perhaps speed things up. It may lead to no further hearing before the Court of Appeal, and those are matters to weigh. But we have, on this side of the court, weighed them up and felt that the balance was in favour of these matters being remitted, and I hope your lordships, my lady, appreciate why we say that. Subject to that, unless your lordships, my lady, have any questions, I'm afraid that is all I have to say to you.
Thank you, Mr. Thornley.
Lords, my lady, just to show the court how closely interrelated these issues are, technically and legally, could I just invite the court to take Mr. Kitchen's judgment, which is at tab 5 of the ring-bound binder, and ask the court to go, please, to, and I do apologise at the outset, there are no page numbers on this document. It did take Mr. Justice Kitchen 6 months to produce.
Well, the paragraph numbers are very clear. Which paragraphs do you want?
Paragraph 34, it actually starts below paragraph 33, common general knowledge, dealing with immunology. And immunology is at the centre of this case. And what the judge describes in the paragraphs that follows is how the immune system works in paragraph 35. What sort of cells we're talking about, what antibody responses are, and going over to paragraphs 40 and 41, he explains how these cells act, these B and T cells, and describes how antibodies are synthesized, and he describes antibodies between 41 and 42. And he goes on to proceed how antibodies are produced and how you can produce, for example, in 47, useful pharmaceutical products by the use of variously engineered forms of antibody. And of course, both parties are developing antibodies, and I'm going to come to that because at the heart of this issue, in many respects, are the claims that my Lord Walker identified, the antibody claims 13 and I forget the numbers of the other two. They've had 3 sets of numbers in the course of these proceedings, 18 and 19,
18,
I believe they
yes.
are. And of course, there isn't a great deal of commercial interest in selling a DNA string or indeed a protein. Although if the protein had been useful, there might have been. In fact, the protein has been shown not to be useful. But could I show the court, going on to paragraph 130, because the patent and this judgment goes in and out of the question of the use of the protein and the use of the antibody. And the reason for that in paragraph 130 of the judgment, because what the patent does in paragraph 123 is to identify a series of conditions for which the protein itself might have been useful. And then a whole load of things are issued. So the hope of the patent is, well, if we squirt this Nutrikine alpha into people, it might do something. And then in paragraph 131, conversely, the patent explains in 143 that antagonists, such as neutralizing antibodies, might have an equally wide range of activities and uses. So the patent then paints the converse. Well, if the protein doesn't do something for your benefit, then maybe having an antibody which mops up an excess of this protein in the system might do something in the alternative. Because what the antibody does is it mops up the protein by latching onto the protein and taking it out of the system. So what the patent was saying is, it may be that we can inject some protein to make you feel better, or we can take it away to make you feel better in a number of ways, which are then explained in the judgment. If I could ask the court to go on to 253 of the judgment. We come to the pharmaceutical and diagnostic composition claims section. And this was said by the judge to be important. And this is the section whereby he found in my client's favour that the importance was the purpose of neutralising antibodies as a recurring theme throughout the evidence. Because the issue here was with an antibody, how can you have a diagnostic or a pharmaceutical composition of an antibody unless you know what it's neutralizing and why you're neutralizing something? And if you don't know what the function of the antibody is, then you're not going to know how you can use it. And the judge explains that over the paragraphs from 252 to 257, and findings that I don't believe are findings of fact are challenged. That, for example, in 257, anyone seeking to develop a candidate antibody to Nutrikine alpha based upon the teaching of the patent would have been faced with a substantial research project with uncertain outcome. And that he then builds on by reference to what the parties did. And he picks it up at 259 and says you've got a research programme on your hands to find out what. And therefore he finds in 260 that it follows from his findings that the specification is wholly insufficient to allow the inventions of these claims to be performed over their whole scope. Now, the question was raised, well, is there a point of law going to arise here? And the answer to that, in my respectful submission, is quite likely. Because if one goes back to 250, where the judge found in HGS's favour was to find, so far as the broad claim 13 was concerned, in 250, he says, in the light of all this evidence, I am satisfied that it didn't require undue effort to make and identify specific antibodies to Nutrikine alpha at the prior date. This particular allegation of insufficiency therefore fails. Now, we understand it to be the law, and we respectfully submit that Lord Hoffman in Biogen stated it to be the law, that you have to be sufficient across the breadth of the claim. And it's a curious position if you find yourself in the position that the claim to all and every antibody, whatever it does, is sufficient. But the actual claims that cover the practical uses, the two of which are either to diagnose or to treat, are somehow insufficient. And since those account for, we would say, effectively 100% of the breadth of Claim 13 in terms of any form of useful antibody, we are submitting, and we submitted in our skeleton argument to the Court of Appeal, that this is wrong, that somehow, the useful claims fall, but you're still caught by the antibody claim because it doesn't stipulate a use. And that is really at the heart of the question of the antibody insufficiency on claim 13. And if I could then come back to the question that my own friend Mr. Thorley was addressing, is it appropriate to hive off what can be referred to as the antibody insufficiency issues apart from the other insufficiency issues? And in my respectful submission, the answer is no, principally for two reasons. The first is, in my respectful submission, we are going to have to brief the Supreme Court in our cases on the law of insufficiency anyway. And I say that because one of the issues that is agreed between the parties to be addressed is the insufficiency of Claim 1. This is issue B2 on the list, on the basis that nucleokine alpha activity on our case is part of the claim as a matter of construction. And I won't weary the tribunal with it now, but there has been some further learning from the European Court of Justice on this issue in relation to a case called Monsanto, which my own friend Mr. Tappian is aware of, just how vital the question of function is. And it's going to be our submission that function is part and parcel of what a nucleokine alpha polypeptide is. Now, the judge found against us, and he said, no, it's just a polypeptide. You can put a line through nucleokine alpha, and provided you can make a polypeptide, whatever it does, then that claim and the sequence claim for that polypeptide is sufficient. Now, Mr. Thorley, in the Court of Appeal, before Mr. Justice Kitchen, accepted the proposition that if the claim was not susceptible of industrial application, then it was necessarily insufficient. So clearly it makes sense for those issues to go together because, on that case, Mr. Thorley has accepted that proposition. However, as I pointed out in our skeleton, we don't accept the converse. For example, let us assume on industrial application, it's considered that it is at least plausible that this protein is responsible for T-cell co-activation, which was essentially the plank on which the EPO Board of Appeal found it was plausibly useful. Now, we say the trouble with that is that it took HGS a 2 to 3 year research program to find out what the protein did. And all they could find was B-cell activation, which is why it's called BAF, for B-cell activating factor. And they published a paper which actually said, we've looked for activity and we can't find T-cell activity. And this weighed on the judge significantly in his judgment. And in those circumstances, we say, even if you clear the hurdle of plausible that it does T-cell co-activation, if you, after 2 to 3 years, can't find it, nevertheless, this claim is not disclosed, or being able to perform it is not disclosed clearly enough and completely enough for it to be performed. So in our case, we say we can lose on industrial application on their plausibility approach, but still win on sufficiency. And when those sufficiency arguments are, as they are agreed to be, part and parcel of the issues that are coming to the court, in those circumstances, we are going to have to address the law of insufficiency come what may. And if we're going to have to address the law of insufficiency come what may, it makes sense as well to address that law in the context of enablement across the breadth, in the case of the antibody insufficiency issues as well. For the very reason that I introduced my submissions to the court, that the technical issues are by and large largely intertwined as well. And it has an air of unreality, in my respectful submission, to be considering function of the protein, function of the DNA encodes, without actually looking at the broader picture, which is the question of what this is actually directed to as a matter of practicality, which is trying to get some form of useful antibody. And I hope in the course of those submissions I've addressed my Lord's point, a question as to whether there was a point of law. My learned friend Mr. Thorley, in his submissions to the court, put store on the fact that, well, there's going to be an issue on the image clone. And there's no doubt that that is, both parties are agreed, a self-standing, self-contained issues. It concerns matters of mathematic algorithms for pipeline screening, which I'm delighted, I hope we never get to, but we may do if it's remitted back to the Court of Appeal. But so far as the sufficiency issues are concerned, there is still the point that I would wish to make to the court, that my clients would wish to have commercial certainty sooner rather than later. And we believe and will submit that we will be successful on the lack of industrial application. Failing that, we would wish to be successful as soon as possible on the question of the insufficiency of the antibodies. In a sense, we've got claims 18 and 19 in the bag, and we'd like claim 13 to suffer the same fate on the issue of law that I've identified. And I am mindful of the fact that the written or claim form, it may have been a writ at the time, was issued in 2006. And at the time of these proceedings, my learned junior, Mr. Burse, went from being a junior to a silk to a county court judge, which is rather indicative of the fact that these proceedings have been on foot a little while. So we would wish to achieve certainty. Now, it may well be that we don't get it ultimately. Let's assume that we actually do then go down on the question of both industrial application and insufficiency. Well, then, of course, we would still want to say it's obvious in the light of the image clone. But at least we've got as far as we feel we can, rather than having those insufficiency issues remitted in the meantime. So for all those reasons, I would urge that the issues that we've identified in terms of the antibody issues, antibody insufficiency issues, form part and parcel. And in fact, I've sold myself short. Mr. Thorley, in terms of timing, says it would be 3 days plus 1. So there's rather more overlap on his case, whereas I said it'd be 2.5 days, 1.5, with the extra issues. So maybe I should have said 3 and 1. But the difference is marginal. Best part of a week, come what may. And in those circumstances, that points to that. And I should finally just mention, of course, it is so far as the other aspect that is disputed, but it hasn't had a mention, is the fact that we have an allegation of unlawful extent of protection. And so far as that is concerned, I've explained the background to that in my skeleton argument. But what they did in the European Patent Office is in the antibody claim, they deleted the words binds to the nucleokine alpha portion of the nucleokine alpha polypeptide. So those words no longer appear in claim 13 when they did appear in the granted claim. And prima facie, our position on that is when you remove a limitation from a claim, you extend its scope because there's one less thing as the patentee that you've got to prove. It no longer has to bind to the nucleokine alpha portion of the nucleokine alpha polypeptide. It just has to bind somewhere to the full-length protein, irrespective of binding to that narrower section. I hope in that narrow exposition I've indicated how short the point is, but it's a very important point. A very important point because, again, if it's successful, hitherto it's not been, for reasons I don't understand, I think it's my own inadequacy, but if it is successful, then, of course, it would be another reason why the broad antibody claim would fall. But it's a short point of construction, whether taking out nucleokine alpha portion extends the scope of protection or not. And in a sense, it does form part and parcel of the other issues in relation to how do you construe claim 1 referring to a coding sequence for a nucleokine alpha polypeptide. Does that just mean a polypeptide with no function? Or does it mean a polypeptide with nucleokine alpha function, or whatever that may be? So we would respectfully urge the court to follow the course of asking us to brief the court on the antibody insufficiency issues and the extent of protection issue as well, rather than remitting them back to the Court of Appeal.
Thank you very much. Do you want to say anything, Mr. Thorley?
My Lord, my Lady, I can be very brief. My learned friend, as always, makes the technology sound disarmingly simple. I can assure you it's not. speaking personally. And the fact remains that to get into the antibody issues in the question of considering the evidence and the weight to be placed on the evidence, you will have to be burdened with more technology than otherwise. That's the first point. Well, my learned friend says there is a point of law, a potential point of law of importance. I'm not sure that I share his view, but of course I can't say there isn't a point of law. This question of broad claims being sufficient, whereas narrower claims are not, has come up frequently in patent law, and the reasons why you keep your main claim but you lose your narrower claim are well considered in previous judgments, and I'm not sure that I would be able to say that it was a point of law of general public importance, but I can't rule that out. The real question that comes down here is the extent to which my learned friend's desire, an understandable desire, to get commercial certainty should be balanced against the normal process of the court system being followed, with the Court of Appeal examining whether there is an error of principle in the evidential approach of the judge before this court is troubled with issues. So it's a straight balance. I can understand my learned friend's desire to get rid of this case, but equally I trust that your lordships will appreciate my client's desire, with the potential that this patent holds for them, to have the matters properly resolved in the normal way. My lords, my ladies, subject to that, I have nothing further to add.
Thank you. We will retire to consider the matter. We are grateful to Council for their submissions. We have to take a case management decision in a fairly summary way. On any patent appeal of this complexity, the Supreme Court, like the House of Lords before, very much values the benefit of the considered opinion of the Court of Appeal. And it is regrettable that in this case we don't have the benefit of the judgment of the Court of Appeal on a large number of reasons. It's also unsatisfactory that it's very difficult in the absence of a judgment of the Court of Appeal on these points to determine whether any of what I call the subsidiary points would raise a point of general public importance suitable for consideration by the Supreme Court. But it's not within our powers to send it back to the Court of Appeal at this stage and ask for a further judgment. That's not something that we can do. And so we have to make the best of it that we can. And what we've decided is that the Supreme Court should hear only those issues which the parties themselves have agreed. In other words, we rule in favour of Mr. Thorley's clients on this. In the light of that, the time for the hearing will be 3 days, and we gratefully accept the offer of the help of Dr. Murphy, and in due course there'll be discussions between the parties and with the court as to what practical arrangements should be made for that.
My lord, my lady, I'm grateful for those indications. Presumably the costs of today are costs in the appeal.
I don't think you would wish to persuade us otherwise, and we would not, I think, decide otherwise. No, there'll be costs in the appeal, and whether Mr. Tappin's attendance will ever this morning will be reflected in that is something that someone else will have to decide.
I'm sure my clients wouldn't let me loose without a minder. So,
Right. Thank you very much.